So I think we have all our presenters. And so I take this opportunity to welcome all to this particular webinar on fair dealing and other exceptions. This webinar has been organized by KECOBO in partnership with AFL and KLISC. And KECOBO is the Kenya Copyright Board, and we are glad to have the members from KECOBO on board. We also are glad to have the members of AFL on board, and also KLISC members. I've seen quite a number of them who are already logged in. So I take this opportunity to invite you to this particular webinar. As you are all aware, copyright matters are very sensitive matters, and since we work for institutions that deal with a lot of scholarly communication, a lot of research activity and publications, I think it is very, very important for librarians, mainly the librarians currently in Kenya and also, of course, other parts of the world, to understand issues pertaining to copyright. And of course, something that goes hand in hand with copyright are the exceptions, the limitations and exceptions. And today we shall be learning more on fair dealing and other exceptions. The Kenya Copyright Board actually has a huge mandate to overly oversee and administer and enforce copyright and related rights in Kenya. And then we have AFL, which is the Electronic Information for Libraries, which is an organization, is an international organization, which is not for profit, and its main mandate and objective is to enable access to knowledge for education, learning, research, and sustainable community development. AFL mainly supports libraries in developing and transition economy countries, and has really been on the forefront to encourage libraries to ensure that in whatever activities they perform and any duties that librarians perform in their various sectors, they actually adhere to the copyright laws in the various countries. And they have been very, very particular in creating awareness about the limitations and exceptions, which will enable librarians to perform their duties effectively, at the same time adhering to the copyright laws. KLISC is the Kenya Libraries and Information Services Consortium, whose main objective is to subscribe for electronic resources and provide access to these electronic resources in all its member institutions. So these three partners, that is KECOBO, AFL, and KLISC, has actually organized this particular webinar, and we are glad that today we have a number of presenters who will be talking to us about the copyright issues, about exceptions and fair dealings in our country. And with those few remarks, I just want to introduce myself and say that I'm Jane Grace Kinyanjui, University Librarian at Egerton University, which is based in the Rift Valley in Kenya, and I will be your moderator for the afternoon. And with those few remarks, I want to invite Mr. Edward Sige, who is the Executive Director of the Kenya Copyright Board, to give us the welcoming remarks and open the webinar. Welcome, Mr. Edward Sige.
Thank you very much, Jane Grace, and good afternoon, panelists. It's my pleasure to be here this afternoon to participate at this webinar. And I wish to thank KLISC, IFL, who are partnering with KECOBO this afternoon for agreeing to work with us. This is not the first time, and I think we'll continue working together. I must say, issues of exceptions and limitations, or fair dealing or fair use, and are really a neglected area of copyright, in that copyright is a balanced system consists of rights to the rights holder and also rights to the public. And intellectual property officers and authorities have been accused of neglecting to educate the public about their rights or the free uses they can have of copyright works. So this afternoon, I'm happy that we are having this discussion, and this area is not simple. This is a very complicated area even to those who practice copyright or who have experience. And we hope in the area of maybe electronic documentation, in the area of books and library, we'll have some light at least on how to manage copyright. So I'm really very happy, and I hope and look forward to having further discussions around this area. Thank you very much, and I wish you a very enlightening afternoon. I'm happy to see so many of you. We've read a lot about Denise, Desmond. I've met Jonathan many times, and of course, Teresa, we've met a lot and interacted at WIPO. I like your passion, and let's hope we'll soon meet in person. Karibu and welcome.
Thank you very much, Mr. Edward Sige, the Executive Director, KECOBO, for those welcoming remarks. We indeed are very, very grateful for you spearheading this particular webinar. And at some point, we were actually getting concerned that we are not talking much about copyright issues in Kenya. So this is really a welcome move, and we really, really appreciate your initiative. And we pray and hope that these collaborations and forums will continue so that we can enlighten our librarians and information professionals so that as they perform their various duties, they are aware of the Copyright Act and the exceptions and limitations. I want to take this opportunity to welcome Teresa to just say hi to us before I introduce the first speaker. Teresa, please just say hi to the participants.
Yeah, well, thank you very much, Jane Grace, and thank you, Edward, for the for the kind introduction. So, and on behalf of IFL, I would like to thank also KECOBO for hosting this webinar on fair dealing and the copyright exceptions. And we can see that KECOBO has a really impressive program of user education and copyright clinics and webinars on a whole range of current topics. So we're delighted that fair dealing and exceptions are featured today in the program, because exceptions and limitations are sometimes overlooked in discussions, as mentioned by Edward, and sometimes they're misunderstood as well. Yet they are an integral part of the copyright system, and they are so important for education and research and the free flow of information in society. So we thank KECOBO and KLISC, our library partners in Kenya. We thank our experts for joining us here today, and we look forward to the conversation. Thank you, Jane Grace.
Thank you very much, Teresa. I also now take this opportunity to really appreciate what, Teresa, you are doing to really help librarians, especially in developing countries and transition economies, to carry out their duties effectively and efficiently with full knowledge of the Copyright Acts in the various countries and the limitations and exceptions that are available for us as librarians to utilize to be able to serve our users effectively. I now want to take this opportunity to invite Professor Joseph Kavulya, who is the chairperson of KLISC, to also just say hi. I know he will talk later in the program, but just to greet the participants.
Thank you very much. Thank you very much, Jane Grace. Mine is to say a word of welcome. Welcome to Kenya virtually for those from different places. We really appreciate the fact that you all experts and panelists have spared the time to come and help us reflect on this matter. We appreciate the role of KECOBO over the years to try to clarify and work with the librarians and as well as other partners to ensure that everybody has a chance to access information and everybody has a chance to benefit from the information that is generated in Kenya. So mine is just to say welcome even to the members of KLISC, the heads of institutions, everybody feel at home, and let us openly discuss this matter so that we can be able to gain and enrich ourselves so that we can be able to be better mediators of information. Thank you very much.
Thank you very much, Professor Kavulya. As participants, as you have heard from the three key people who have just given their remarks, today's forum is very, very important. And the main objective of this particular webinar is to create awareness on the rights and exceptions in the Copyright Act, to raise awareness on how libraries, research, and education sectors can utilize fair dealing and other exceptions in the Copyright Act. And number 3 is to identify challenges in using fair dealing and other exceptions, and especially in Kenya. And number 4 is fair dealing in the region, the experiences of other countries, and from the experiences of other countries as they present, as librarians in Kenya, we are going to learn a lot, and we shall be able to improve on the way we offer our services to our users. And finally, the evolution of fair dealing internationally. We are also going to hear what is happening in other regions. So that is those are the main objectives of the webinar today. And I hope that we all shall learn something by the end of the day. It's supposed to be a 2-hour webinar. And so we shall really be able to move very fast. The presenters have 10 minutes to present. And then the question and answers session will be at the end of the presenters. I think that is how we had planned it, and I hope that is still the case. So I just want to urge the participants to be noting down their questions, and also you can also use the conversation forum or platform to raise your concerns, your comments and questions. And then at the end of the presentations, we shall be able to respond, to get the responses from the various presenters. So I want to take this opportunity to invite the first presenter, Dennis Nicholson, to give us an introduction on the fair dealing and other exceptions. Nicholson is retired from the University of Witwatersrand, Johannesburg, South Africa, in 2020, after about 38 years professional service in various library posts. Her last post was Scholarly Communications Librarian, and she managed the Copyright Services Office for the university. In the year 2021, she started her own consultancy firm called Scholarly Horizons, and she has been also working in that area using the many years experience in copyright issues, open access, and scholarly communication, and is well recognized internationally, regionally, and also in South Africa for her advocacy and promotion of access to knowledge and for more balanced copyright laws in South Africa. She is an expert advisor to international, regional, and national library groups. And in 2021, she was actually awarded 2 prestigious awards, the Sally Trust Liasa Lifetime Achievement Award and the UNISA Chancellor's Calabash Award for being an outstanding educator. So I take this opportunity to invite the first presenter to give us her presentation. Thank you. You're most welcome. Yeah, that's what happens with technology. When you think you are ready, it just disappoints you. But we hope we will have her on air so that she can be able to share. I see that she was able to share even her screen. So I hope she'll be able to talk, and we'll be able to hear her as she presents.
We could continue with my presentation. I think logically it's, since I'm talking about history, we can start at the beginning.
Okay, I think if that is agreed, we will have Jonathan Band, who was supposed to be the second presenter, present before her, and then she can present later. Of course, it would have been better if she had presented because she was just going to give us an introduction, but I think it's still okay. We will still be able to get the information. So I want to take this opportunity to introduce Jonathan Band, who is going to present to us this afternoon the evolution of fair dealing internationally. He is going to give us experiences out there that would help us to maybe get 1 or 2 ideas on how we can go about it in Kenya. And Jonathan Band is actually, I think, an attorney, and he is an adjunct professor at the Georgetown University Law Center, and he has helped shape the laws governing intellectual property and the internet through a combination of legislative and appellate advocacy. He has represented clients in the US with respect to the drafting of the Digital Millennium Copyright Act, the Stop Online Piracy Act, and other federal and state statutes, and by filing amicus briefs in the significant cases related to these issues. Mr. Band has represented clients also in connection to the Marrakesh Treaty, the Anti-Counterfeiting Trade Agreement, the Trans-Pacific Partnership Agreement, and the Transatlantic Trade and Investment Partnership, the United States, Mexico, and Canada Free Trade Agreements, and other international agreements. Mr. Band also has written extensively on the intellectual property and the internet, including books in Interfaces on Trial 1, Interfaces on Trial 2, Interfaces on Trial 3, and over 100 articles. So we really want to take this opportunity to invite Jonathan Band to share with us the rich experience that he has. You're welcome, Jonathan Band.
Thank you very much. I hope, first of all, can everyone hear me?
Yes, we can hear you.
Okay, great. The most important thing. So thank you very much for having me. I'm going to spend the next 10 minutes talking a little about fair dealing and its history and how it has evolved internationally. Next slide, please. So fair dealing was first developed by the English courts in the 18th century in response to the reality on the ground. The Statute of Anne was adopted by Parliament in 1710, and very quickly courts recognized that if you took the statute literally, all kinds of legitimate activities, things that should be lawful, would not be. And so the courts, on their own, in the English common law tradition, started allowing certain uses when they thought they would be fair. And from out of this evolved the concept of fair dealing. It was adopted by US courts in 1841 in Folsom versus Marsh. That was a Supreme Court decision. But when the United States adopted it, instead of using the British terminology of fair dealing, they used a new terminology, fair use. But the roots of US fair use are in British fair dealing. And again, this was all done by courts in an effort to achieve the balance that we heard about earlier. Next slide, please. So the courts in England continued to interpret cases, and out of this body of cases, in the Copyright Act of 1911 actually contains a codification of the case law that had been developed by the British courts. That was then adopted or incorporated into the copyright laws of the various colonies. And then after the colonies achieved independence, most of the colonies continued to retain the fair dealing provision within their laws. Meanwhile, in the United States, all the way until 1976, fair use was entirely a judge-made concept, and you had to look at decisions to understand what was fair use. It was then codified in 1996 in the U.S. Copyright Act, which distilled the case law into statute. Since then, fair use has been adopted in numerous countries. So you can see places like Liberia, obviously they look to US law given their history, Israel, Singapore, Malaysia, Korea, the Philippines, Taiwan, and some other countries. And so what they did is rather than, but you'll notice that Israel, Singapore, Malaysia, of course, were all former British territories, so they already had fair dealing in their laws. So for them to go from fair dealing to fair use was not a huge step. On the other hand, for places like Korea, adopting fair dealing was a large break from their legal tradition. And we'll talk a little bit more later on about why they would have done that. Next slide, please. So here you see a map of fair use and fair dealing around the world. So the green is the fair use countries. The blue is the fair dealing countries. And so this is a good visual representation of how the sun never set on the British Empire. So a lot of the world doesn't have fair use, but certainly, again, in terms of time zones, every time zone does have fair use or fair dealing. Also, more significantly, is the number of people who live in regimes with fair use or fair dealing, especially when you include India, Pakistan, and Bangladesh, as well as the United States. You get about a third of the world's population, maybe a little bit more, and over 40 countries. So fair use and fair dealing are very widespread around the world. Next slide, please. So what exactly is fair dealing? What exactly is fair use? So fair dealing is a relatively flexible exception where basically in the first sentence you see that's a paraphrase of the law as it appeared of the British of the English copyright law from 1911, and it says fair dealing for the purpose of research, private use, criticism, review, or news reporting is not infringement. And so that phraseology appears in all of these different fair dealing countries that I referred to, all these former British colonies. Sometimes it's in one section, sometimes it's in 2 or 3 different sections, but that's the basic formulation. Also, interestingly, in the 100+ years since it was adopted in these various countries, it has evolved in all kinds of interesting ways. But the core is fair dealing for these purposes. Now, fair use, which is the next paragraph, this is a summary of the fair use provision from the United States. And it says fair use for purposes such as, we'll talk a little bit more about that, such as criticism, comment, news reporting, teaching, scholarship, or research is not infringement. And then there are these 4 factors that a court is to consider in assessing whether a particular use is a fair use: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the use, and the effect of the use on the marketplace. So next slide, please. So you have these 2 basic approaches of fair dealing versus fair use. The main difference is fair use has a closed list of purposes, while fair use is open-ended. So we saw with the fair dealing, it said for the purposes of, and it listed the specific purposes. Whereas fair use, it uses the words such as for purposes such as criticism, commentary, and so forth, and therefore is open-ended. So those purposes are exemplary, they're not limited. And so that is seen as the main difference between fair use and fair dealing as they have evolved, that fair dealing is somewhat more flexible. Additionally, fair use has those factors. It tells the court what it's supposed to consider, whereas fair dealing typically does not. Now, again, what we've seen as over time, as the statutes have evolved in different in different countries, is sometimes you still have the closed list plus the factors. So you see that especially in the Caribbean, where in places like Jamaica, where they originally had the British, the closed list of purposes, but then they added the factors. And so again, different and other countries have, so what Malaysia and Singapore did is they started with their closed list and then they inserted such as or including to make it more flexible. And a fair question is, are these distinctions between fair dealing and fair use, are they real? Many people will say, well, fair dealing is closed, fair use is open, but is that really the case? So next slide, please. So as I said, since 1911, many of the former colonies have amended their fair dealing to look a lot more like fair use. Also, importantly, courts have interpreted in the fair dealing countries, courts have interpreted research broadly, right? So that's one of the factors. But research can mean all kinds of different things. And one of the main issues is, does research include non-commercial research? Is it limited to non-commercial, or could it include commercial research? Now, at the same time, in some jurisdictions, the fair dealing has become a little more narrow. So in some countries, so for example, in Kenya, as you know, in the fair dealing provision in Kenya, it only applies to scientific research. In other countries, like now in the UK, it's non-commercial research. But in Singapore, when they were looking, they interpreted research broadly, and this is when it was still fair dealing. They interpreted research broadly to include commercial research, and in that case, it was reverse engineering of software, because they thought that it was too constraining. And subsequently, they actually amended the law to make it look more like fair use. Then we have in Canada, the Supreme Court interpreted a fair dealing provision, which was a closed list without factors, and they interpreted it to be similar to fair use. Now, obviously, the Canadian courts were looking to their neighbor to the south, and the case law and the statute in the United States, and they interpreted their fair dealing as equivalent to fair use. And we even have some scholars that say that the English common law and the 1911 Act was actually open-ended, that people are sort of misinterpreting the Act to say that it has to be exactly, fit into one of the specific purposes that are included in the fair dealing provision, and that there's more flexibility there than meets the eye. But the bottom line is that there is a degree of flexibility, and it's important to understand that certainly in the United States and in all of these fair dealing countries, in addition to the fair use or fair dealing provision, there are a list of specific exceptions. So, for example, many of these countries have exceptions for libraries, and these are in addition to the more general, more flexible fair use and fair dealing exceptions. Next slide, please.
You have 1 minute or two. I hope you are about to finish. Okay,
this is the last slide. So the question is, what are the implications for Kenya? As I mentioned, the Kenyan fair dealing provision is very much like the traditional UK fair dealing approach. And so my suggestion would be to add the word "such as" to section 26(1)(a). So right now it reads for the, by way of fair dealing for purposes of scientific research. And all you need to do is just add the two words "such as," and that makes your statute more flexible and more able to adapt to all of the new technological uses that we see in this digital age. Another approach is to sort of do what Israel and Singapore did and just adopt a provision that is more like the fair use provision in the United States. That's, on the one hand, more open-ended. On the other hand, it provides courts guidance by listing the factors. In any event, I've put together with a colleague a handbook that has all of the fair use and fair dealing provisions from around the world, and you can sort of flip through that and see how different countries have adapted fair use to their domestic situation. And again, it's very interesting from a legal history point of view to see how starting with the British approach, the English Copyright Act of 1911, how now over 100 years of development, you have all of these different options. I'll be happy to answer questions in the question and answer period later on. Thank you very much.
Thank you very much, Jonathan Band, for that presentation. It was indeed very informative. It is important for us to know what is happening in other countries so that in Kenya we can also do the right thing. So we will now invite Professor Joseph Kavulya, who was supposed to present as the third presenter. Professor Joseph Kavulya is the current chairperson of KLISC, and he is also the current university librarian of Chuka University in Kenya. And Professor Kavulya has worked for 24 years at Catholic University of Eastern Africa as a university librarian, and has 6 years as the university librarian and an associate professor of library information science in the Department of Computer and Information Science of the same university. He is also, as I said, the current chair of KLISC, and his areas of research interest is digital libraries, informatics for development, library information science education, and take this opportunity to invite Professor Kavulya to give us his presentation, which is on challenges. He's going to present something on challenges in using fair dealing and other. Welcome, Professor Kavulya.
Thank you.
As he's presenting, I just want to remind the participants that all these presentations will be shared later on. All the slides will be shared to all the participants. Kindly keep on noting your questions so that we can answer them at the end of the presentations. Welcome, Professor Kavulya.
Thank you very much, Jane Grace, for your introduction, and thanks everybody for the continuous sharing. My short presentation is on some of the challenges facing librarians in Kenya in regards to fair dealing and other corporate exceptions. And as you have heard from the presentation by Band, there is already a problem with our in the way we have framed our corporate issues. But I want to thank everybody that we have agreed, our experts and presenters have agreed to come to help us reflect on this matter, so that we can see how we can maximize the use of information as a vital resource in sustainable development in Kenya. We thank Kobo, AFOL, and distinguished panelists for agreeing to share your time with us and to reflect on this matter. As a national consortium, Kenya Libraries and Information Services Consortium We have a vision. Actually, our vision is information access for all. And we have defined our mission as facilitating acquisition, access, and sharing of knowledge and information resources for education, research, and information. And of course, these commitments are based on the axiom that access to knowledge is the only firm foundation on which sustainable development can take place in the 21st century. We all know by nature the mandate entrusted to librarians. They have to make access, organize, store information to support research, teaching, and learning, and fulfill information needs of ordinary citizens. Secondly, they are expected to transform, sometimes transform, reproduce, store, transmit information in new formats. For example, downloading for patrons, information in digital formats, making accessible copies for those with disabilities, and transforming formats through processes such as digitization for purposes of preservation. 3, we are also expected to make copies for the libraries through interlibrary services. And above all, and in recent developments, we are librarians, especially in academic institutions, are expected to advise on matters of scholarly communication. And a lot of these touch on copyright issues. And therefore, you can see copyright issues are very critical to librarians today, and they continue to struggle with them globally, and this, in particular Kenya. There's evidence that shows that library researchers in Kenya in the past have been trying to grapple with this issue. And at the center of this all is issues to do with fair dealing, limitations, and exceptions. Now, for us, or from my perspective, fair dealing, limitations, and exceptions, there's a promise. The question is it a panacea for copyright restrictions as we know it or we practice it in Kenya? And the promise is this: it is good news for librarians, because it means that you can be able to fulfill your mandate, my mandate, without a lot of, without fear, without uncertainties, and effectively. But globally and in Kenya, the situation is different. Even with the provisions of fair dealing in our copyright law in Kenya, we find ourselves constrained in addressing information needs of our respective user communities. Actually, there is evidence, or there's been claims that copyright infringement in Kenya is endemic. And Kenya universities and their libraries have been frequently accused of not doing much to curb copyright infringement. Even before, as a decade ago, when we used to have the AVU, African Virtual University, there was a feeling that there was a lot of violation of copyright measures. Okay, and many people, many stakeholders accused librarians of conniving with others to steal copyright rights. And whether this is true or not, if librarians are guilty or not as accused, this is a persistent problem to copyright law in Kenya. And LISC professionals and other stakeholders have to condemn, and if not addressed, will continue to hinder access to information and any efforts to transform Kenya into a knowledge-based society. We have had cases where there has been many litigations, or very heavy litigations, and a number of institutions in the last decade have paid a colossal amount of money in compensation for supposedly flouting corporate provisions. In the past, publishers and associations have accused librarians of conniving with thieves to steal from them and others. Actually, we have gone to conferences where we have invited publishers in Kenya, and sometimes you left flabbergasted because of being accused of conniving with people to steal from publishers. And we recall with the zeal with which the now suspended copyright sought to impose or to negotiate reprographic licenses with universities on the basis that universities are making copies of cases, even tables and other excerpts from textbooks, magazines and journals for exams, teaching, class, and so on and so forth. So this leaves us wondering, really, where are we? What should be done? According to literature, as well as anecdotal evidence, some problems include the following. Most librarians, including library researchers, have no access to legal advice from the institutions. Of course, there are exceptions like Aga Khan University. There's a resident attorney in the library to advise the library on legal matters, including copyright issues. Secondly, there's general lack of information or general lack of informed, open-minded legal minds who can give definitive guidance and who are willing to positively support librarians to maximize provision of fair dealing. Many lawyers in Kenya, you engage them, it is actually a legal battle, and you leave almost more confused than before. So nobody can give definitive guidance. In my experience, or very few, I've not come across many, and possibly support librarians on what they should or how to proceed with this matter. So it's a very contentious issue even among the legal minds in the country. There's always a continuous pushback against limitations and exceptions from publishers. Those who have attended conferences and meetings, discussions, forums with the publishers in this country, they are very aggressive when it comes to protecting their rights or the rights of their authors. And therefore, librarians are left right in the middle of the road. Of course, librarians themselves do not have maybe adequate information or awareness of what to do, how to proceed, how to implement all these provisions in fair dealing, limitation, and exceptions. And therefore, there's a real problem. So some of the outcomes of this situation are these. One, librarians have actually become like gatekeepers. In the library, they are more active to try to protect the corporate law than to provide information, especially when they fear that there could be a controversy, we can end up in legal or litigation against the institutions. So they better prefer not to do much, maybe just ensure people are not misusing or flouting the corporate. Number two, most universities are overly conservative in the interpretation of corporate law and often neglect their own interests, adding unnecessary costs and obstacles to lawful dissemination of information. And therefore, you find the corporate law sometimes is just that people are afraid of. Even if you have one copy of a book, you better find ways of ensuring as many people read it, rather than make some copies of a page or something like that, and so on and so forth. So we have a situation where people are refusing to act, and thereby librarians, for example, not being able to fulfill their mandate, and as such, access to information being constrained. These are the issues that I managed to get maybe from not a really major research, but they give us an indication of where we are. There is a problem and interpretation, and we are here to hear how we can proceed with the matter. Otherwise, thank you very much for your attention.
Thank you very much, Professor Kavulya, for that presentation. It is good we know the challenges that are facing librarians in Kenya, and we are here to learn even from other librarians and information professionals elsewhere, how they have gone about these challenges and overcome them. So we now take this opportunity to invite Dr. Desmond Oriakhogba. I'm sorry if I don't I don't pronounce your name properly. You will kindly pronounce it for us so that we do not cause injustice to your name. Desmond is a senior lecturer in the Department of Mercantile and Private Law in the University of Venda, South Africa. Desmond obtained his LLM and LLB degrees from University of Benin in 2019, and obtained a PhD in commercial law, focusing on intellectual property and competition law from the University of Cape Town in South Africa. He is a senior lecturer in the Department of Mercantile and Private Law in the University of Venda, South Africa, and an independent consultant with the World Intellectual Property Organization, which is WIPO Academy. He is a Queen Elizabeth Scholar and research collaborator with the Open Africa Innovative Research Network and the South African Department of Science and Innovation, stroke National Research Foundation Research Chair on the Intellectual Property Innovation and Development in UCT. Desmond was called to the Nigerian bar in 2008 and was a visiting researcher in the Center for Law, Technology and Society in the Law Faculty, University of Ottawa, Canada in 2018. Desmond is also an author of Copyright, Collective Management Organizations, and Competition in Africa, Regulatory Perspectives from Nigeria, South Africa, and Kenya, which was published in 2021. We now take this opportunity to welcome him so that he can also give us the perspective, maybe from Nigeria or any other areas that he has practiced and has some experience in. Thank you so much. Welcome, Desmond, for the presentation.
Thank you very much. I'll just try to share my screen briefly. Please let me know if you're seeing my screen. I'm sharing. Yeah, I think you can see my presentation.
Okay, yeah, we can see the way the poster. I think the presentation will proceed. We'll continue from there.
Okay, thank you very much. Just trying to make it bigger. Yes. All right, so that everybody can we can see easily. Please just let me know if it is okay. If okay, so I will thank you. Thank you very much, first of all, for the opportunity to join this conversation. I'll be going straight up to. I'll be looking at the these issues that I've highlighted in the overview. History of copyright law in Nigeria, the ongoing copyright reform. We'll focus here on the timeline and the milestones. We would also focus on key features of the executive and private bills. We'll look at the key exceptions in the executive bill, and then I will reproduce the fair dealing provision in the executive bill to show to us what Nigeria is doing and how Nigeria has been able to, how Nigeria is trying to get around its present copyright predicament. Now, the beauty about my presentation is that it's coming at a time when Mr. Band and Professor Joseph have laid necessary foundations. So it will be easy for for participants to engage with my presentation as I get along. Now, it is important to note that there are copyright reforms happening everywhere, across Africa. I'm sure if we're following events, we'll be very familiar with what is happening now in South Africa and the interest that is making that the process of the law reform in that country very slow and excruciating. Of course, Namibia is another country that is carrying out its reform right now. Nigeria is also one of the countries that's also carrying out reforms. ARIPO, as an organization, is trying to include voluntary registration in its voluntary registration of copyright in its IP system. And I also saw somewhere that Kenya, too, even though it concluded its process last year, it still has some works on copyright reforms. In the heart of these reforms at national levels, mainly is copyright exceptions and limitations. And so that will be the main focus of my discussion today. All right. And what my presentation will be focusing mainly, like I've said before, on the Nigerian experience. But before getting into the heart of the discussion, it's important to know where we are coming from so that we have an understanding of where we are in Nigeria at the moment. Like as a British colony, our copyright law, the history of our copyright law is traceable, or is linked to the development of copyright in the UK. That is understandable. And of the UK Copyright Act of 1911 was extended to Nigeria, in 1912, and the purpose for that was mainly to protect British works. At that point, nobody really cared about copyright exceptions and limitations, even though that act has some provisions that could probably term a little bit open at that time. Of course, the question of knowledge of copyright law at that time in Nigeria was also not as it is today, even the interest too. But that system continued in Nigeria until 1970, when the military head of state then, were under military rulership then, promulgated Decree number 61 of 1970, which was the Indigenous Copyright Act in Nigeria. Not long afterwards, in 1988, another decree number 47 of 98 was enacted to replace the 1970 decree. And of course, that 1998 decree was modeled after the Waipo-Tunis model. The essence or the rationale behind this amendment or this replacement was not basically about copyright exceptions and limitations, but mainly because there were provisions in the 1970 decree that they felt were not strong enough to protect owners of copyright works, and also because Nigeria needed to bring its law, in tune with the Berne Convention. Okay, and of course, that decree has been the Decree 1998, which is actually the extant Copyright Act that we have in Nigeria, has been amended twice, in 1992 and in 1999. In 92, the essence was to bring in a comprehensive regulatory body that we have today, the Nigerian Copyright Commission, and also some provisions around collective management organizations. In fact, the 1999 amendments was also aimed towards tightening or strengthening the collective management organization regulatory framework in Nigeria. So the focus was not really on copyright exceptions and limitations. But in 2012, a process began, within the Nigerian Copyright Commission to amend or to enact a comprehensive act that would bring Nigeria's law in tandem with what was happening, the current reality at that time, which was mainly propelled by digital copyright issues. And so that process led to the production of a draft copyright bill for public comment in 2015. After the comments, revision of the draft copyright bill took place, and we heard nothing until in 2018, when there were news reports that that bill has been approved by the Nigerian Federal Executive Council as an executive or public bill, for the Nigerian Copyright Commission and the Ministry of Justice to forward to the National Assembly. Just to note that the Nigerian National Assembly is made up of the House of Senate, the upper chamber, and the House of Representatives, the lower chamber. This information is important because of what I will say, soon. Okay, so again, we didn't hear anything. The policymakers went to sleep until earlier in 2021, when a private bill. Now, a distinction must be drawn between public and private bills. Private bills are those bills that are sponsored by private individuals in Nigeria, either a member of Senate or a member of the House of Representatives or an NGO, as the case may be. But public bill or executive bill are bills that are sponsored by government organizations, government agencies, or like in this case, the Federal Executive Council. All right, so in early 2021, a private bill was sponsored to repeal the extant Copyright Act and to enact a new Copyright Act. Now that bill was sent to the Senate, the Senate of the National Assembly. It passed second reading in June 2021, and then it was referred to the Senate Committee on Trade and Investment. Now, the good thing about this move by that private individual, that is a sitting senator, was that it propelled the Nigerian Copyright Commission and the other government ministries and the government agencies that were involved in the process to quickly now send the executive bill to the Nigerian Senate. So later in 2021, the executive bill came to the Nigerian Senate. It passed the second reading in September 2021, and it was referred to the Senate Committee on Judiciary, Human Rights, and Legal Matters. So at that point, we ended up having two bills, the executive bill and the private bill. So there was now a need for harmonization, a need for the bills to be brought together, so that one does not trump the other. That led to a process which began first by an internal consultation organized by the Nigerian Copyright Commission, a consultation with experts in the field. So there was a technical consultative meeting that held in October 2021, and that meeting was just meant to galvanize support for the provisions of the executive and the private bills. All right, and the next thing that occurred was a public hearing, a joint public hearing that was organized by the committee, the Senate Committee on Trade and Investment, and the Senate Committee on Judiciary, Human Rights, and Legal Matters. The essence was to gauge public views, public, perception about both bills. As someone who partake in that hearing, representing IFO and PG, I could gauge that the public perception on both bills as one of acceptance, general acceptance, especially with regards to the executive bill. And the reason for this will be obvious, as I get along. But just to state that it is interesting that unlike the experience in other parts of Africa, like South Africa, for instance, there was general public support for the bills, maybe because the attentions were not focused on the exceptions and limitations, but on other aspects, like aspects that relate to collective management or copyright, which we're not focusing on today. And also, thankfully, probably because the usual suspects, the international bigwigs within the creative space, were probably didn't pay much attention, to what is happening in Nigeria. And I hope that continues anyway. But the point is, now the public hearing went on. It was successful. There was a general acceptance of the bills, especially the executive bill. And the Senate, both Senate committees have now to go back get into their offices and work with their officials to harmonize the bill so as to produce a single bill before the National Assembly for consideration. The commitment, at that public hearing was that this process will be done before December 2021, and so that we would have a Christmas gift in form of a new copyright bill, copyright act. That didn't happen, but I'm aware that in March, by March this year, there will be a report on the harmonization to the Nigerian Senate. And after that report is done, the next step will be for the Nigerian Senate to, pass the bill. There will be a third reading, and of course, there will be a passage. And once that is done, the bill will be sent to the lower house, the House of Representatives, for concurrence before it will then be sent to the president for assent. So that is just it about the timeline and what is happening at the moment as far as the bills are concerned. Now, I said that we have two bills now. Interesting as it is, two bills, the executive bill and the private bill. So on this slide, I've tried to bring out the key features.
We can't see the slide, by the way. The slide has remained. We can't see the slide, and you have 1 minute left.
Ah, interesting. I thought my slide was.
Oh, it's not moving. It's not moving. I can see it, but it's not moving.
It's not moving.
Yes. Maybe you can just proceed with your presentation.
Just proceed.
Okay. All right. So I'll try to quickly round off. There are some key features in the bills. Just to note that the executive bill has 109 sections, while the private bill has 72 sections. The executive bill has just one schedule, and the private bill has 5 schedules. But the private bill is structured after the extant Copyright Act. Then another key feature is that the executive bill has more open and balanced, balanced and flexible exceptions. But the private bill still retains largely what we have under the Extant Copyright Act, which is a closed exception regime, except for the introduction of a Marrakesh-styled exception for blind and blind persons and persons that are otherwise disabled. All right, now the provisions in the executive bill, because like I said, its exceptions are more flexible, more balanced, more open. So I'm going to focus on those provisions and leave out the private bill. The executive bill has in section 20 a provision that looks like the UK style fair use, but which is couched fair dealing. We'll see why I regard it as US style fair use in the next slide. Sadly, you said we can't see the slides. All right, so it also has provisions for persons with disabilities beyond what the Marrakesh Treaty provides. That executive bill also has provisions, again, specific provision for the Marrakesh-styled exceptions. And it has exceptions for copying for purposes of instruction and examination. It has exceptions for recording of broadcasts by education establishments, exceptions for reprographic copying by or on behalf of educational institutions. There are exceptions, special provisions for archives, for libraries, for museums, for galleries, GLAM. And of course, there are exceptions there's a compulsory license regime. It's sad that I don't know why that's the case, that you can't see my slides, but this last slide, or the last major slide, presents the fair dealing provision. If you take your mind back to Mr. Band's presentation, it drew a distinction between, one of the major distinctions between fair use and fair dealing is that there is this open-ended provision for fair use, the provision of such that the use cases are not limited to those that are highlighted under the act. In the case of Nigeria, although the provision uses fair dealing, it has that provision such as making the use cases open-ended, and thus, making it look like what we have under the US Copyright Act. In fact, there are also provisions on the factors to be considered when fairness is discovered, is being determined, just like we have under the US Copyright Act. I'm sorry that you couldn't see my slides. I don't know why that is so, but thank you very much for the opportunity. Thankfully, also the slides will be shared with participants, and I am open to questions.
Thank you very much, Desmond, for that wonderful presentation. It was unfortunate that the slides were not moving, but because we are going to get these slides, I think it shall be well. Thank you for giving us the history of what has happened in Nigeria, and I think the Kenyan professionals can copy or get one or two ideas from there and see how they can be able to create more awareness, and especially for the benefit of the library and information users. Thank you very much. The next presenter, I don't know whether Dennis was able to.
Can you hear me now?
Yes, we can hear you. Thank you.
Good. Okay, at last.
Yeah.
We have
Okay. So we will have your presentation. Thereafter, we shall have a presentation from Paul Kaindo. So welcome, Dennis Nicholson, and present to us. I think I had already introduced the speaker, so I think we'll just go ahead and let her present what she has to ask. Thank you so much.
Good afternoon, everyone.
Minutes.
I hope you can hear me.
Yes, we can hear you, and we can also see your slides, so it's okay. Just proceed.
I was told I had 15 minutes, so is that possible?
You have 15 minutes. Participants, kindly continue to note down your questions, and after this presentation and the last one, which will be from Paul Kaindo, we will be able to take questions and also give answers. Thank you. Welcome.
Thank you. I want to thank the Kikoba and Eiffel for inviting me to speak to you today, and I thank Jane, Grace, Edward, Teresa and Joseph for the warm welcome and introduction. I will be giving an introduction to fair dealing and other exceptions in copyright law. It's a bit backwards because I couldn't get in first, but my overview is, I'll just want to see if the boss said. I'll be covering these topics: authors' rights, balancing copyright law, limitations and exceptions for national legislation, fair dealing, examples of other exceptions, and limitations and exceptions in developing countries. There is no international copyright law. There are national copyright laws drafted within the framework of international IP agreements. Copyright law gives a bundle or suite of exclusive rights to authors to protect their works for a certain period of time. The minimum period in international IP agreements is 50 years after the author's death. Many countries have extended this period to 70 years or more, but it is more advisable for developing countries to keep to the 50, as they are net importers of intellectual property, and the main beneficiaries would then be developed countries if they extended it to 70 or more. The 5 fundamental rights of authors include the right to reproduce the work, for example, through photocopying or scanning, the right to prepare derivative works, including translations and adaptations, the right to distribute the work to others via an exclusive or non-exclusive license, or even an open access Creative Commons license, or via a sale or other means, the right to display, broadcast, or perform the work publicly, and the right to let others exercise any of these rights. The purpose of copyright is to encourage creativity and learning for the good of society. Limitations and exceptions are the key mechanisms which ensure a balance between the rights of authors and the larger public interest. Limitations and exceptions allow for copyright works to be used without a license or having to get permission from the copyright owner. The international copyright system recognizes the importance of limitations and exceptions to secure the promise of knowledge goods to improve the welfare of society as a whole, by encouraging creativity and promoting dissemination. However, historically, the central importance of limitations and exemptions for the fulfillment of copyright goals has not been emphasized. Limitations and exceptions to the exclusive rights of authors are provided for in international IP agreements. The Berne Convention mandates free uses, example, quotation, illustration for teaching and the reporting of current events, and permits limitations on protection for political speeches and speeches delivered in the course of legal proceedings. The WTO TRIPS agreement carried forward public interest principles in its objective. And the WIPO Copyright Treaty and Beijing Treaty for Audiovisual Performance both recognize the need to maintain a balance between the rights of authors and the larger public interest. The type and number of limitations and exceptions are a matter of national sovereignty and differ from country to country. Determining factors include legal and cultural traditions, socioeconomic factors, national intellectual property strategy, and policies. A country may adopt exceptions as are deemed necessary and appropriate, provided they are in line with their international obligations. The TRIPS agreed statement concerning Article 10 permits members to extend existing limitations and exceptions for the digital environment and to devise new ones that are appropriate for the digital network age. In practice, robust exceptions can be hard to achieve, especially in developing countries, due to a variety of reasons, including pressures from bilateral trade negotiations, multinationals, strong rights holder lobbies, and lack of capacity. An international instrument at WIPO for limitations and exceptions for libraries and archives, education and research would be a great step forward. IFLA, IFL, and Alliance Partners and the Africa Group have been working towards this for many years as part of the WIPO development agenda. The 2013 Marrakesh Treaty for the Visually Impaired was the first WIPO treaty to address limitations and exceptions, or rather users' rights, for people with disabilities. Exceptions and limitations can be expressed as a general provision, such as fair dealing or fair use, as well as separate specific exceptions for education and research, libraries, archives, museums, and galleries, for people with disabilities, etc. In the digital environment, specific exceptions can be adopted for computational analysis, digitization, and other purposes too. So what is fair dealing? Fair dealing is an exception that provides a closed list of specific permitted acts that can be done without a license or permission from the rights owner. It is a list of possible defenses against an action for infringement of an exclusive right of copyright. It allows you to use other people's copyright protected works for the purpose of research, personal or private use, private study, education, quotation, criticism or review, judicial proceedings, news reporting, parody, satire, and a few other limited activities. You would be required to acknowledge the source where applicable. There is no magic figure for fair dealing of 5% or 10% of a work. Unfortunately, fair dealing is not generally defined in copyright laws, nor are there any criteria for users when using copyright works. Users tend to either be too conservative in how much they can use from a work, and in many cases rather apply for permission and pay a fee, even though there is fair dealing, or they copy as much as they need regardless. The latter leads to infringement in many instances. If an act restricted by copyright does not fall into one of these categories, the act will be unlawful unless a license has been obtained from the copyright owner. Generally, a use will be fair if you are copying for a valid reason, you don't copy more than you need, you give attribution where possible, and your work is not directly competing in the market against the original. If there's litigation, what is fair would be determined by a court. Copying a number of pages may be fair in some instances, while copying just one page may not be fair where it is the essence of the work. The courts would apply various criteria and considerations, so each case would be considered on its merits.
Your slides are not moving.
Oh dear, because they are showing on my side.
Okay. Now that's good.
Shame. Okay. Personal or private use. Reproduction for private purposes and research is one of the most universally accepted limitations and exceptions to the right of reproduction in national copyright laws. The need for a person to make copies for a variety of non-commercial purposes in their everyday lives is widely recognized. It would be impractical and onerous if permission had to be obtained for each and every copy, and it would serve to hamper the free flow of information in society. Fair dealing for personal or private use allows any natural person in any capacity to access and reproduce a work, whether analog or digital, for personal, recreational, entertainment, civic, educational, or any other non-commercial purpose. For time shifting, example, recording a TV program for viewing at another time. It also permits reproduction of a portion of a work for the purposes of doing research, being involved in research, or collaborating in research-related activities. This includes scholarly research, but goes far wider. Example, researching a topic of special interest for career development, researching new diets or exercise programs, or one's family history. Here are just a few more examples of personal or private use, but there are many others. Learning a new skill, example, a language or hobby. Finding information for civic purposes or to prepare for an interview. Development of fair dealing. As Jonathan said, fair dealing was first developed by courts in England in the 18th century and was codified in 1911. Fair dealing became incorporated into the copyright laws of the former British imperial territories, now referred to as the Commonwealth countries. Fair dealing is not as flexible a concept as the US concept of fair use. Unlike fair use, fair dealing cannot apply to any act which does not fall within one of the mentioned categories, although common law courts in some jurisdictions are less stringent than others in this regard. For example, if your copyright law does not include digitization and preservation or text and data mining in either the list of acts under fair dealing or in a separate exception, then you may not do it without permission. Although Kenya has fair dealing in its copyright law, in recent years the court have found it necessary to apply the 4 fair use factors in some cases. And I've given you a link to the article on the slide of the particular case. Examples of other exceptions. In addition to fair dealing, exceptions or provisions, copyright laws can include a number of other exceptions where certain acts can be done without copyright clearance or the payment of a license. Without such exceptions, prior permission or license would be necessary. Here are some important examples that countries need to include in their copyright laws. For libraries, archives, museums, and galleries. We need reproduction, preservation, digitization, interlibrary loans, replacement of damaged or stolen works, making backup copies, procuring missing parts from another library or information service, format shifting, conversion from old to new technologies, assisting a blind student for purposes of converting an article into an accessible format, allowing librarians to read extracts of books on YouTube or other online platforms, and to use copyright materials for non-commercial exhibitions or commemorative events, assisting authors to deposit their work in an institutional repository, indemnifying librarians when duties are done in good faith, and showing a film or playing a whole work for educational purposes. For education, we need exceptions for sharing teaching material via course packs, e-learning platforms, a US flash drive, email or PowerPoint slides, including portions of works in printed or electronic form in an assignment, portfolio, thesis or dissertations, assessments, examinations, personal use, deposit in an institutional repository, sharing articles with fellow educators for preparation for teaching, conferences or research. Research or academic activities, sharing with other academics for discussion on specific topics or research, or with rural academics who do not have access to up-to-date resources, or for collaborative projects, or applications for 3D, artificial intelligence, virtual reality, text and data mining, circumvention of technological protection measures for lawful purposes, example re-engineering or repairing software on a ventilator, using video clips or adapting images or other graphics for theses or dissertations with acknowledgement. For people with disabilities, the Marrakesh Treaty has made it possible for copyright works to be converted into an accessible format and share accessible formats across borders. This includes blind and visually impaired persons or other reading challenged persons, but the exceptions in national copyright law can expand to include persons who are deaf, dyslexic, or who have other disabilities. Countries need to ratify this treaty to benefit from cross-border exchange of accessible formats. Orphan works, making it possible to use such works where the rights owners are untraceable. Translation, being able to translate works into indigenous languages or sections for teaching and learning. Open access options for deposit of manuscripts of articles in open access institutional repositories to enable the creation of open educational resources and to use Creative Commons licenses. Temporary copies. These are machine generated, but an integral part of accessing and using digital material. So these are all examples that should be in copyright law. If your country is updating its copyright law now or is planning to, have a look at the very practical exceptions and other information in the Eiffel Model Copyright Law. I've given you the link on the slide. Developing countries have a role to play by actively implementing limitations and exceptions in a manner that best suits their domestic needs, especially the need to stimulate local creativity and enable access to knowledge. In addition, the international system must more explicitly recognize, emphasize, and promote the critical role of limitations and exceptions in ensuring follow-on creativity and promoting diverse forms of creative engagement. The role of limitations and exceptions in promoting public welfare is a matter of extreme importance, not only for users of knowledge goods, but for creators as well. In a digital world, the line between users and creators has become blurred. Users are creators and creators are users. Libraries, for instance, are now users, custodians, creators, producers, and publishers. Everyone across the spectrum needs access to information, and limitations and exceptions are the key to access. Without the appropriate balance between protection and access, the international copyright system not only impoverishes the global public, but ultimately it undermines its own ability to sustain and reward the creative enterprise for the long-term future. You may like to read the article by Ruth Okadiji. The link is on the slide. I'm sorry if you're not seeing my slides, but you will get them. I've given you a whole slide of useful resources, including the Eiffel Model Law, Jonathan Bland's Fair Use Handbook, and many other resources. Conclusion, to the extent...
Sorry.
Can you see it?
Yes.
Good. In conclusion, to the extent copyright law is an integral aspect of shaping the conditions necessary for human flourishing and thus foundational for national economic development, the design of international and national copyright law matters a great deal. The pressure to harmonize copyright law and the long practice of doing so only in the direction of strengthening exclusive private rights has made it unnecessarily difficult to adjust the system to accomplish goals that are important for the welfare of developing and least developed countries. National copyright laws need to be as flexible as possible to enable access to knowledge, use of copyright works for education, research, civic, professional and career purposes for people with disabilities, etc. Fair dealing, together with specific exceptions for the above purposes, is key to a balanced copyright law, but fair dealing is limited, especially in the digital space. It does not have the flexibility and future-proofing options that fair use clauses have in the US and 12 other countries. As Jonathan said, over the past century, the fair dealing statutes have evolved in many of the Commonwealth countries and increasingly resemble the fair use statute in the United States. The evolution of fair dealing to fair use in court decisions indicates that fair use is more flexible than fair dealing in the digital world. Thank you very much for your attention, and I'm sorry for the technical problems.
Thank you very much for that very, very detailed presentation. Indeed, that is why it was supposed to be an introduction, because it has given us a lot of information about copyright and fair dealing and exceptions and limitations. But all the same, even though it was not the first presentation, we have also learned a lot. And I think the participants will be able to get a lot of information, even from the slides, which will be shared later. Participants, I hope you are still taking your questions and comments down. We are about to finish the presentations. We will now invite the last presenter, who is Mr. Paul Kaindo. Mr. Paul Kaindo is Senior Legal Counsel at Kekobo, and he is an advocate of the High Court in Kenya. He has vast experience in intellectual property management and enforcement, dispute resolution, contracts and commercial practice. He holds a master's degree in intellectual property from University of Zimbabwe, an LLB degree from Kampala International University, and a postgraduate diploma in law from the Kenya School of Law. He previously worked in private practice and was also a law lecturer at a middle-level college in Nairobi. So we take this opportunity to welcome Mr. Paul Kaindo to give us his presentation. I don't know whether he is able to hear us.
Yes, I can hear you. I'm not sure whether you can hear me.
Yes, we can hear you very clearly.
Thank you, Jane Grace. I hope you can also see my screen.
Yes.
Thank you. So thank you, Jane Grace, and thank you to the previous presenters, Denise, Joseph, at the presenter from Nigeria.
We can't see the screen.
Okay.
The host kindly.
The host can.
There it is now. Oh.
Okay. Okay. Thank you.
But I hope all will be well. Yeah, we can see it now. Thank you.
Okay. Okay. Thank you. So I'll take the shortest time possible. So in the interest of time, I'll just jump in. So I like what Joseph M. Kavulya said earlier, to the difficulties in ensuring that the libraries are able to use the exemptions and limitations, because that they are varying advices from the practicing lawyers. But I believe that the reason is because there is also a debate on between the property rights and human rights, which supersedes the proponents of property law rights simply say that these property rights should actually supersede human rights, and human rights proponents say that it should actually be the other way around. So to bring a balance between the two, the law simply provided that, yes, we do acknowledge the rights of the property owner, in this case, the copyright owner, and we also acknowledge the human rights of the public. We are aware that there is the right to access information. So to balance that, The law in Kenya particularly, because I'll be presenting on what the Kenya Copyright Act provides in relation to exemptions to fair dealing and exceptions. So it provides for the exemptions at fair dealing in provisions at the section 26 subsection 3. There is also section 26A and also 26C. 26C is a reproduction of the Marrakesh Treaty. It is the one that provides for the exemptions by the visually impaired persons and persons who are print disabled. In relation to section 26, subsection 3, it provides for the general exemptions under the Copyright Act, directs us to the second schedule. Then section 26A provides for the exemptions in relation to computer programs, which are also subject to the exemptions under the second schedule. I'll jump directly to the general exemptions, which are provided for under section 26.1. Under the second schedule, Part A provides for the general exemptions, and it says that it is the exclusive rights under Section 26. These are the exclusive rights which were mentioned by Denise Aria, that if that the doing of any of those exclusive rights by way of fair dealing for purposes of scientific research. Earlier, somebody did mention that it is specific to scientific research, private use, criticism, or review of, as well as reporting of current events. So that is one of the exemptions. It also applies it applies across the board, including sound recordings. Then the exercise of these rights by way of parody, pastiche, and caricature. So if it is for the purposes of parody, pastiche, or caricature, of course, it will be an exemption under the second schedule of the Copyright Act. Then the right to quote, of course, as long as it is compatible with fair practices and it is justified, is also an exemption that is actually identified under the second schedule, as well as judicial proceedings or any reporting of any such proceedings. As like you are aware, in Kenya, we have introduced the virtual hearings. So recordings of such judicial proceedings and recordings and reporting of such proceedings will also be protected, will also fall under the exemptions and limitations. The other exemption under the second schedule is the production and distribution of copies or the inclusion in an audiovisual work of a broadcast of works which are placed in a place where they can publicly be viewed. Of course, that has in the past elicited different debate. And it is similar to the next general exemption, which is the incidental inclusion of a copyright work in an artistic work, sound recording, audiovisual work, or a broadcast. The operative word there is incidental inclusion. It is left to the court to determine whether it is incidental or not. The last general exemption under Part A is the reading or recital in public or the broadcast by one person of any reasonable extract from a public work, if accompanied by sufficient acknowledgement of the author, would actually fall under the exemptions under Part A, subpart 1. And all these general exemptions have, again, a rider that there has to be sufficient acknowledgement of the author for them to actually those are the general exemptions. Then the second schedule goes right ahead to provide for exemptions for specific areas, starting with educational institutions. B of the second schedule, and it provides specifically for about 5 exemptions, at least 4 exemptions which apply to educational institutions, which are specifically defined under the section 2 of the definition section of the Copyright Act. They include the inclusion in a collection of literary or music works of not more than 1 page of a work, and that also includes an acknowledgement of the title and authorship if the work in question is designed for use in a school or in a university. a school is specifically defined under the Act, falls under specific acts, as well as a university. So they use the inclusion of not more than one page by such would actually be an exception for educational institutions. Secondly is the non-commercial reproduction for teaching in educational institutions of previously published articles or extracts of such articles, as long as that reproduction is justified by the purpose for which they are reproduced. And again, there is no collective management organization that collects in that area. Of course, if there is a collective management organization in that area, then they should actually seek for a license. This would be a reprographic license in relation to that. You'll note that this is not a reproduction of the Act as it is. I did summarize what is in the on the slides. Then the broadcast of our work, if the broadcast is of course intended for purposes of systematic instructional activities, as well as reproduction or rebroadcast of those broadcasts for the use by schools and universities for purposes of systematic instructions by those schools or universities as defined in the Act. The operational words there are for purposes of systematic instructional activities. And again, there is a requirement that these there should be an acknowledgement of the author. So those are the exemptions under the second schedule's general exemptions at educational purposes. Then libraries and archives under the second schedule of the Act also have been benefit from some exemptions which are enumerated under Part 1 of Part C of the second schedule. And there are generally two, like I've enumerated there, and they include the reproduction of a work under the direction of a government or a public library or archive. It must be for a non-commercial documentation or scientific purpose. That institution must be doing them for purposes that are besides commercial. So no money should actually be derived from such reproduction by the government or by the public libraries or archives, as well as the making of a single copy, notice the operative word, single copy, of books which are not available in Kenya. It must be under the direction of either a person in charge of a public library or an archive for purposes of archiving and preservation. An exemption which is granted to broadcasting organizations. They include the reproduction of a work under the direction or control of a broadcaster, where that broadcaster has been granted that authority by the right holder. These broadcasts are, of course, authorized by the copyright owner, and they are destroyed within 6 calendar months immediately following the making of the reproduction, or of course, depending on the terms of the license with the copyright holder. So that reproduction for purposes of broadcasting within the license terms of the right holder would actually fall under the exemptions and limitations, as long as they're destroyed within 6 months. But if there is a rider under that provision that if that work is of an exemptional documentary nature, then it may be preserved. However, it cannot be rebroadcasted or it cannot be used for any purpose unless authorization and consent is derived from the owner of that work. And of course, broadcasting of work that is already lawfully made accessible to the public would also amount to an exemption under the second schedule of the Copyright Act. I had also the benefit of also mentioning the exemptions which may not directly be in the second schedule, but when you look at the body, at the text of the Copyright Act, particularly after the amendments in 2019, there are at least 2 exemptions, which one of them operates in relation to computer programs, 26A, and the exemptions apply to computer programs which are reproduced for purposes of making copies, for purposes of correcting errors. So that will not amount to an infringement, and you don't need the authorization of the copyright owner. Making a backup copy, notice the word a backup copy. That means it is just one. So if you reproduce a copy for purposes of making a backup, that will not amount to an infringement of the rights under Section 22. That making copies for purposes of testing a program in order to determine whether it is suitable for the use of the person as he intends would not be an infringement, as well as making copies for purposes that are not, I would actually wish to use the word, that are allowed under the license or the agreement. So if you do any of the acts, even if they are provided for in the act as an exemption, but they are not, they're allowed, then it would actually be to not fall under an exemption. So as long as it is within the license agreement. The other one is decompiling or converting the program. This is of course not reproduction, but decompiling or altering the program into a different version or creating a different language for purposes of enabling the program to operate with other programs would also be an exemptions. And lastly, ladies and gentlemen, is the exemptions which were introduced by the Marrakesh Treaty for purposes of visually impaired persons or persons which are otherwise print disabled. And it is not an infringement of a copyright for an authorized entity as defined in the second Section 2 of the Act to produce or to distribute copies of or sound recordings for purposes of previously published literary works, for purposes of making them available to these visually impaired persons. That would not be an infringement. Notice the reproduction must be by an authorized entity, that is for the purpose of creating specialized formats which are specifically defined in the Act. Secondly, a beneficiary person or authorized entity can make, import, distribute, lead, or share accessible format copies. It can also circumvent technological protection measures which are in place in those works, of course, subject to some terms which may be provided for in regulations, as long as the purpose of doing the circumvention or importing or distributing is for purposes of making these work accessible to the public. And once these new copies have been made, then there must be a notice that further reproduction in any other format other than the specialized format as defined in the Act would be an infringement, and there must be a notice that identifies the owner as well as the date of the original publication. So ladies and gentlemen, that is the end of in the interest of time. Thank you so very much.
Thank you very much, Mr. Paul Kaindo, for that very informative presentation on the Copyright Act of Kenya. I believe that the Kenyan librarians in the forum have learned a lot, or rather have reminded themselves of the areas that the limitations and exceptions apply to. We have come to the end of our presentations. We are now going to the next session, which is the question and answer session. And this session is supposed to continue until 4:25. Thereafter, we will invite a representative from Kekobo with the guidance of Mr. Edward Sigei to make closing remarks. So I want to start off by just reading some of the few questions that I picked from the chat conversation. And the first question is, how is Kekobo enforcing copyright laws around universities? There is a lot of photocopying of books without following the laid down copyright laws. This is a question from Sally Njage, and I want to invite Paul Kaindo or Mr. Edward Sigei to help us in that question. The next question that I picked, again from the chat, is at what point do fair use / dealing meet with Creative Commons licenses? This is a question from Andrew Juguna. I want to invite Mr. Jonathan Band to help us answer that question, or any other presenter. The third question that I picked is, are librarians in Kenya and beyond having a conversation on how to serve the visually impaired persons with respect to the Marrakesh Treaty? I saw that that question has been answered partly by Teresa and Professor Kavulya, but maybe additional information to the participants would help. I want to invite Professor Kavulya to help us in that question. And then the last question that I picked is a member, or rather a participant, wanted to know best practices codes in digital content usage recognized in law. I want to invite again, I think, Jonathan Band to help us answer that, or Denise. Thank you so much. I want to invite Paul Kaindo or Edward Sigei to give us the answer, followed by Jonathan, and then Professor Kavulya and Denise or Jonathan. Thank you.
All right, thank you very much, participants. I've seen a lot of comments and chats on the chat box, and I'm happy to see that a lot of us are following even up to this moment. On the matter of how Kekobo is dealing with the issue of photocopying, by legislation in Kenya now, we are expected, if we take somebody to court, to also move with someone who is complaining. That is the complainant. So at this point, since copycat is no longer in working, and so we only take only action where there is a specific complaint by the author or the publisher who is affected. So in that case, our hands are, we are tied to some extent until and unless there is the organization that represents the publishers and printers in the sector, or else there is a specific complaint. So otherwise, there's no case in Kenya if you don't have a complainant. There's also another question I saw directed to Kekobo about popularizing its services. We are fairly new in Kenyan terms. We are just about 10 years old now as an organization, and we do not have offices all over. But we've been trying to be more visible online, and we do invite anyone who has a team or a group, or have some people gathered together to and would like to have training and learn more, to engage with us, even virtually, like we are doing this time. So we just we invite you to visit our website, follow us on social media, and you will find out more and encourage other people. We do have printed material for the purposes of raising awareness, and we will keep on working with there's something that we are working with IFOL that will assist even on the Marrakesh issue, because this thing is very wide. Today we've only looked at librarians and to a limited extent researchers. But there are other people also who would like copyright works and who would like to know more about it. So if you need more training, if you need more webinars, you need more engagements, just let us know. I'll leave an email here for the purposes of reaching Kekobo, so that we can engage more even after this session. Thank you. Jane Grace, back to you.
Thank you very much, Mr. Sigei, for that answer. I think it's true. I think we need to do a lot more, and we can carry on the conversation in various other forums and webinars. I think this is a good start, and we should just continue until we are all enlightened on matters to do with copyright and how we can handle them. Maybe something that I can just add to that is that as information professionals and librarians, it is also our responsibility to ensure that we adhere to the law, and therefore in every area that we do photocopy, there should be some kind of caveat, or what can I say, something that reminds users that they cannot photocopy beyond a certain limit. So I think we also, as professionals, need to do our duty as we help the board, KECOBO, to enforce the law. I want to invite Jonathan and, oh no, sorry, not Jonas, yeah, Jonathan, yes, first, and then Professor Kavulya.
Thank you very much. So with respect to Creative Commons and fair use, they really, in general, operate in different spheres. So with a Creative Commons license is a license where the creator basically authorizes people to make uses of his or her work, and under certain conditions. So, for example, it might say, you know, they can use the work so long as there's attribution, or they can use the work so long as it's for a non-commercial purpose. And so they are already permitting the vast majority of uses that one would want to make, so you don't need to rely on fair use. I suppose in theory there could be some situations where someone wants to, let's say, for example, someone wants to make a commercial use of a work for which only non-commercial uses are permitted under the Creative Commons license, and could that conceivably be a fair use? It might be a fair use, but it still could breach the license terms because the Creative Commons license basically says it's a license, and so if you breach the terms of the license, you might not be violating copyright, but you might be breaching contract, breaching the license. But as a general matter, that situation doesn't arise because the Creative Commons license is very clear about what it permits, and it does really permit the vast majority of uses that one is likely to make of the work. Now, I didn't quite catch the second question that you had directed towards me.
The question was, are best practices codes in digital content usage recognized in law?
Well, so far, so to just back up, at least in the United States, several groups have put together codes of best practice, and typically that's academics who have led that process to help guide people about applying fair use, and those codes of best practice have been extremely useful for various use communities, and the best example is documentary filmmakers, who, of course, when you think about a documentary film, often makes use of pre-existing works, photographs, clips of film, music, and rights clearance for a documentary could be very expensive and time consuming. And so the question is what could you do under fair use? And the best practices for documentary filmmakers has been very widely accepted among documentary filmmakers, and it's been very helpful to them. It's also been insurance companies that offer insurance to policies to documentary filmmakers have been willing to rely on those best practices because they say, well, and a lot of times if you want to get your film in the United States screened at a movie theater, you need to have insurance, because otherwise the theater is worried that there might be liability for infringement. So insurance companies have been willing to issue insurance to documentary filmmakers, where the documentary filmmaker certifies that they're complying with the best practices. However, to my knowledge, no court thus far has referred to those best practices and endorsed them. And certainly the rights holders, as a general matter, they also don't endorse them because they say, well, they were developed without us. Now, the reason they were developed without the rights holders is because if the use communities tried to develop best practices with the rights holders, they would never get anywhere, right? Because the rights holders' view is everything should be licensed. So you would have this very long negotiation that would go, and no one would go anywhere. So the bottom line is that it's been these best practices have been very useful for the use communities, but so far there has not been, to my knowledge, in the United States or elsewhere, sort of a court or a legislature that has said, that has given a stamp of approval.
Thank you for that answer. I think you have well put it. I now want to invite, in the interest of time, I want to invite Professor Kavulya to answer the question on Marrakesh Treaty and what Kenyans are doing about it. And then I'll come to the next round of questions. Welcome, Professor Kavulya.
Thank you very much, Grace, and thanks for that feedback. I think the matter of Marrakesh Treaty, we had a long chat last year that culminated in a webinar where a number of issues were clarified. Because I'm sure this is a member of KLISC, what we can do is to share the outcome of that, because we had a long discussion on do's and don'ts. And it became clear that we have the green light to implement Marrakesh Treaty in our libraries. Number two, we also resolved that we could develop a guideline, kind of a guide to implementation of Marrakesh Treaty in libraries. I know AFOL and KECOBO are collaborating on this matter, and as KLISC we have been invited to make an input so that we can have a guideline or a code, as we are calling it. So that one I can say that, but I can add that on another matter, that maybe this is to cooperate executive director and his team, and also AFOL, whether it's possible to create yet another kind of a guide for libraries on limitations and exceptions, because it's really a difficult ground. Thirdly, we know it is very difficult for librarians to operate with the courts. It's like everybody is watching librarians to pounce on them and catch them and take them to court and their institutions. So I think we need a better dialogue between, especially the lawyers and publishers and librarians, so that we can have a common ground. But as I've highlighted, in my view, is that maybe the problem we have is a market issue. There's no market for books in Kenya. And therefore, when librarians say we can do this without paying, you're infringing on a very serious financial goal of publishers and others. And therefore, that could be the problem. The only problem is that without access to information, without access to books, we cannot develop the reading culture. And therefore, it goes around again, there's no market. And therefore, I think it's a dialogue that should continue, as somebody has suggested. Otherwise, thank you very much for the opportunity.
Thank you very much, Professor Kavulya, for that answer. Well said. Now, Professor Otike has asked 3 questions. The first question he has directed to Jonathan, though I feel that even Nicholson can also answer that question. And the answer is, why is it that most countries are afraid of having copyright on fair use basis directed? Okay, the question is directed to Jonathan, or I think even Nicholson can also answer. The second question is directed to Desmond. Has Nigeria fully implemented the Marrakesh Treaty in institutions in Nigeria? And his third question was to Paul Kaindo. Who determines the composition of the copyright board. And I think from the remarks from Professor Otike, I think he is trying to say, is there a possibility to ensure that librarians are represented in the board? Thank you. I want to stop there and take the next round of questions, though I don't see any in the chat, but let's just answer those questions and see if there are any other questions that have not been answered. Thank you. I want to invite Nicholson to try and answer that question on why countries, most countries are afraid of having copyright on fair use basis, assisted with by Jonathan. Thank you.
Okay. Can you hear me?
Yes, yes, we can hear you.
Just from our experience in South Africa, there's been a strong opposition to fair use, and it's mainly from multinationals who do not want developing countries to have fair use, although they benefit from it themselves. America has the largest entertainment, publishing and IT industries in the world, and it's contributed, a lot of it is because of fair use. So the multinationals are happy to, have a good profit margin, but they don't want developing countries to have it. And we're having a huge battle in South Africa because we desperately need fair use. Our fair dealing is very limited and it doesn't address the digital world. But the whole argument is that if you introduce fair use, everybody's going to copy everything and not apply for copyright at all. Some examples have been given where they've said that we will copy one textbook and make 2,000 copies for our students. And that is not fair use, that is infringement. But they continue to say that we will do that, despite us telling them that that is infringement. They also say that the publishing industry is going to collapse. Well, there are 13 countries with fair use at the moment, and I've written to most of the academics and librarians in each country, and they all say that publishers are still publishing, artists are still painting, writers are still writing, and it hasn't caused a collapse in the publishing industry. I think the main concern about the introduction of fair use into developing countries is they benefit from us. I mean, we're net importers of intellectual property, so we pay a lot of money over to foreign developed countries, and they like that. They don't want that little pinch in their profit margin. I mean, in South Africa, they've gone to the extent of having a protest in America where they got the US trade representative to threaten trade sanctions if our president passed our bill. The EU also wrote to say, do not pass this bill, and it went back and it's now back in Parliament under review. And it's absolute nonsense that fair use is going to damage anybody. It actually contributes, and Jonathan will probably say this, it contributes a huge amount to the economy in America, be able to use fair use and the production of material through using fair use. Wherever anybody complains that it's going to affect the publishing industry, it's nonsense. It hasn't happened anywhere, and we don't think it'll happen in South Africa either. Okay.
Yeah, no, I share Denise's frustration, and sort of as a U.S. citizen, I'm embarrassed that my government is not more proactive in exporting fair use. They're perfectly happy to export Life Plus 70 or requiring countries to adopt technical measures and so forth, but not fair use. And it is, as Denise said, it's that you have these large entertainment industry, the large entertainment companies, mainly U.S. companies, that rely on fair use domestically, but they don't want it applied internationally. So in their slight defense is, their attitude is that, gee, enforcement is so bad, or there's so little respect for copyright in so many countries around the world that all of these more exceptions will be abused. And that's how they see the world. And my response to them is, yes, it is true that copyright has in many countries in the developing world, it is true that copyright does not have a great deal of legitimacy and that copyright is not well enforced. But part of the reason why that is so is because the copyright laws in those countries are so one-sided. I mean, they're copyright laws from 1911, right? I mean, you have some countries that really haven't amended their copyright laws since the early part of the 20th century. And whereas the copyright laws of the developed countries have been updated repeatedly and have a lot of balance. As a result, the copyright laws in many developing countries, they have no legitimacy. People don't respect them because they realize that they're completely out of date and completely one-sided. So the solution, if you want to have better enforcement of the law and better respect of the law, is to have better laws, more balanced laws, laws that have more credibility with the people. Then people will respect them. And so one of the ways, especially with copyright, is have a 21st century law, have the same exceptions in Kenya that you have in Singapore, right? I mean, why should people in Singapore have more freedom to use works than people in Kenya or South Africa? And so once you make the laws more balanced and more legitimate, then I think people are more likely to observe them. So anyway, it's been a constant battle.
Thank you very much.
Something there, that countries with fair use are using our material, South Africa and Nigeria and Kenya and everybody else's material with fair use, but we can't use our own material under fair use. We got stricter, fair dealing and strict, or we haven't got exceptions for these things. So we're not even able to use our own material, but Jonathan and everybody else in America and that can quite happily use our material under fair use. And I don't think that's fair.
You're right. You're right.
Yeah,
thank you
please.
so much. I want to welcome Desmond.
Yes, thank you.
Yes, Desmond.
In fact, I share the sentiments of Denise and Jonathan. The question of legitimacy actually also has another angle to it. Us as Africans, we are more communal. We believe that properties, things should be owned by the community. In fact, to the extent that children are brought up by the community, I mean, this is one thread that runs through all African countries, right? Now, on the other hand, we have copyright law, which has a history that is different from ours. A history where, that is, the ideas are based on, the ideologies are based on individualism. I should own my thing. The property belongs to me. And it's on that premise that copyright law developed. Now, bringing it to Nigeria, bringing it to Africa, there will be these conflicts, there will be these tensions, because you have a law that is coming from a culture that is different from, the culture in Africa. And the best way to ensure that legitimacy is through these open, balanced, and flexible exceptions, the key of which is the fair use exception, and the other exceptions that Nigeria is trying to introduce. Once that is done, the legitimacy will be achieved. And then, of course, to answer the question pointedly, like Denise has said, it's fear-mongering. It's question of, they begin to bring copyright issues within the context of trade, within the context of, international trade. And once all those starts coming, once African countries start saying that, oh, we will lose aid, we will lose international trade, we will lose foreign direct investment, you see them backing up. And that is what happened in the case of South Africa. You see a complete, U-turn from the government, and that is why in South Africa now things appears to be very slow as far as their copyright amendment bill, the copyright reform process is concerned. For us in Nigeria, like I said in the course of my presentation, somehow, maybe because the process was not very open, it has disadvantages, but I see some advantage in this case. Maybe because the process was not very open, the usual suspects, these international, publishing houses and the rest, didn't quite know what was happening. And I am hoping that within this short frame that we have for the process to be complete, they don't throw all these spanners in the works and make things difficult for us.
Thank you very much. I want to invite you to go on and answer the question that was directed to you about the Marrakesh Treaty implementation in Nigeria. You have muted. Unmute kindly. Kindly unmute.
Okay. To the best of my knowledge, I'm not aware that anything is happening in terms of implementation at the institutional level. You know, I mean, in terms of public institutions. But I'm aware that REPRONIG, that is the Reprographic Rights Organization of Nigeria, the arm that is focused on literary works, the print and publishing industry, the collective management organization in that sector, is doing, that is the equivalent of a Copyken in Kenya. I understand that they have been having some, the process has been on for some time now, with WIPO, that is the arm of WIPO that is interested in, that is working on implementing the Marrakesh Treaty, to implement that treaty within the Nigerian context. But I don't know how far that has gone. But I'm aware also that the current Director General of the Nigerian Copyright Commission, out of his own private initiative, has produced one of his books in Braille. So I can say that as far as implementation of the Marrakesh Treaty is concerned in Nigeria, it's been pushed by private initiative. I'm not aware that there is any actions at the institutional level, other than passage of the Persons with Disabilities Act, which does not quite link copyright with disability rights in Nigeria. But and also, other than having specific exceptions in the Nigerian Copyright Act, nothing seems to be happening in terms of implementation at the institutional level in Nigeria.
Thank you. Thank you very much for that answer. I now finally request Paul Kaindo to answer the last question on who determines the composition of the Copyright Board. Thereafter, I will invite Teresa Hackett after Paul to give Teresa to give a few remarks, and then we will invite Edward Sigay to close the forum, because we are way beyond our time. Thank you. Welcome, Paul.
Jane, I'll actually deal. I'm Edward Sigay. I'll deal with the question.
Okay.
State corporations in Kenya are managed by, the boards are determined by two things. One is circular from the head of public service, and also by the legislation. In Kenya, we have a limitation as to the number of people who sit on the boards of a state corporation. And due to that change, we made certain amendments in 2019 to bring down our board from a potentially 23-member board to 9 persons. Even then, you find that the number of the slots are even limited for the purposes of having representatives of authors themselves. So we have only three areas that are represented in the author side. That is publisher, music, and film or audiovisual rights sectors, based on the size that were chosen based on the size. As such, to answer Otike directly, there are no users of copyright works. There are no beneficiaries of copyright works, and there is unlikely that there will be slots for those categories within the copyright board. So I think I'll leave it there, but then ask Teresa to give her final comments.
Thank you very much, Mr. Sige. Members, I think you'll agree with me that the forum has been very, very educative. And I think, as somebody has already said, we need to have more of this kind of forums so that we can create more awareness about copyright issues, limitations, and exceptions. So I take this opportunity to thank all of you for the wonderful presentations and for the participation by the members. And we hope that soon we will have a similar forum where we can all participate and share ideas. I now take this opportunity to invite Teresa Hackett to make some remarks, and then invite Mr. Edward Sige to make closing remarks. Thank you so much. I have been your moderator, Jenny Grace Kinyanjui, University Librarian at Egerton University, Vice Chair of KLISC, and also the Kenya representative or coordinator of copyright issues in AFL. Thank you very much.
So thank you very much, Jane Grace. Can you hear me?
Yes, we can hear you very clearly.
You can hear me. Okay, I'm just checking. So I would also like to extend my thanks to you for moderating our session and for for navigating away through all the technical issues and the changes in the program. But I think we in the end had a very rich and a fruitful discussion, and has raised some given some ideas and raised some questions. And I think for me, one of the main questions is, how can we help to develop the confidence of librarians in Kenya in using the copyright law? Because as we heard, there are exceptions in the Kenya Copyright Act. There are specific exceptions, and then you have the general fair dealing. And when these provisions are put into the law, we want the communities to use them. So maybe we can think about how can we help to develop that confidence. The issue of best practices came up in the chat, and I gave an example of some guides that the UK Intellectual Property Office has done on exceptions. So maybe we have some ideas there that we could, that we can take forward for next steps. And then I also, as Edward mentioned, there are other communities. I mean, we've just spent the day really talking about libraries, but there's other communities too, like researchers as well. And in fact, in about 3 weeks' time, on the 3rd of March, we will have another session looking at the issue of artificial intelligence and text and data mining and digital research tools. So there are many interesting areas that I think we can all explore. So I think this is the start of a conversation, and perhaps from that then we can build on some practical tools and advice to help people in a really, to help the library community in Kenya in a really practical way. So I thank you very much for all, everyone for your presentations. And with that, I'll hand now over to Edward. Thank you.
Thank you very much, Teresa, for those comments.
Okay, thank you.
Yes.
Yeah, okay, thank you very much, Jane Grace, for moderating very well. And I think the sessions have been so good that we have not noticed the time is flown. Yes, and I wish to thank the presenters also for sparing their time and researching and preparing. And I would suggest that all of us use the email that I gave so that we can put together the presentations for us to be able to share with our participants. With the participants, I wish also to thank you for your attendance and participation and engaging. Finally, I wish to say that we've taken one step in dealing with a very complex issue. And let's keep on having these discussions. We have taken note of the comments on the chat as well, and we'll seriously consider them. As Kenya Copyright Board, the next frontier for us in terms of reform of the law is this area of exceptions limitations. There are these areas, and there are many other areas. As always, we face the challenge of having how to manage the conflict, the competing interests of publishers and the public, and also to protect the professionals that work in this area. So the next set of reform will be focusing on this, and I think your contribution as librarians will really be very, very key when you're called upon to give your comments. So I wish again to thank the librarian community for all and for working with us. And as you mentioned, you had we have the next session very soon on AI. These are emerging issues as well that we need to have an eye on. So with those many remarks, I wish you a very good evening. And thank you for attending.
Thank you very much, Mr. Edward Sigay, for those closing remarks. And we really, once again, want to say that we really appreciate you are hosting this forum. And we hope that we have just started and that we will continue working together so that we can create more awareness about copyright issues in Kenya, so that our librarians and information professionals can serve their users better for the benefit of the country in terms of sustainable development. I take this opportunity to thank all of you. And participants have given their email addresses through the chat. So I'm hoping that the host has been taking note of that and that the slides and the presentations will be shared to all the participants. Thank you very much. May God bless you. Have a nice evening for those who are in the evening session, and have a nice day for those who are just beginning their day. Thank you very much.
Bye. Thank you.
Bye. Thank you very much.